Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is attorney Michael Demaray from Los Gatos, California. My first thought when I thought about Michael, because I've known him for quite a long time, he's very well known in the legal community here. And so my analogy for Michael is the old Gunsmoke series with Marshal Matt Dillon. He was the first man that they looked for and the last one they wanted to see. And that's the way a lot of attorneys in the area feel about Michael when it comes to estate litigation in the estate area. So Michael has been in practice for many years here in Santa Clara County. His practice focuses mostly in estate litigation, but he also does some estate planning and administration. So mostly estate litigation. What do you think, about 80%, Mike?
Yes, at least.
Okay. Anyway, before we get started, I've got a little reminder to people. We're talking today about your rights as a beneficiary. It's the topic that we're talking about, and we're in California. The laws vary somewhat from state to state. We always suggest that you should get independent legal counsel. This is a huge area. We're just going to sort of scratch the surface and give some basic information. Michael is a California attorney, and so that's what his background is as far as giving an area. So you need to get your personal information from a good attorney. So just to sort of kick it off, Mike,
attorney.
a good local attorney.
Yeah.
Well, okay, possibly. Some people, they decide to go outside their area if they can't find that local talent.
Mm-hmm.
You know, they need a great litigator, and they're in, Puyallup or something. Maybe they'll come to you, Mike. Anyway, just to sort of get started, Michael, why don't you tell us a little bit about, what is the status of estate litigation type of situation here
Well,
in Santa
both
Clara County?
lawyers generally feel that that's an area that's expanding rapidly because of what I call a certain socio-economic dynamic, which is the doctors and the advances in medicine are keeping our bodies alive longer, but our minds often can't stay up there. Plus, in addition to that, we have ours and our parents' generation with incredible wealth compared to their parents' generation. People that own, say, a house in Santa Clara County often could be worth $1 million without much more. Plus, we have an enormous number of second marriages. 50% of the marriages in California divorce, and men especially don't like being alone in the second half of their life. Mm-hmm. And so then you have children by the prior marriage. And then finally, on top of all that, you have children that either because they don't have the economic opportunities that we had, or because they've been raised in a very upscale environment that they expect us to continue to maintain for them after they turn age 18. All of that leads to a lot of lawsuits over estates where in the past there weren't that many.
Okay. All right, so let's put ourselves in the perspective now of the beneficiary. And so I'm a beneficiary, and I had a close relative who died. How can I find out if I have an inheritance?
Well, the law says two things. It says, one, if the person who died had a will, the law requires the custodian of that will to lodge it with the Superior Court of the county in which the decedent died within 30 days after his death. So theoretically, 30 days after his death, if you think you might be a beneficiary, you can go down to the Superior Court of that county and ask to see the most recent wills that have been lodged, and you'll find out if there's a will and if you're a beneficiary. We also now have what are called living trusts, and the law there says that within 60 days after the decedent dies, his trustee is supposed to send a notice to the interested persons, the beneficiaries of the trust, the persons who would be the heirs if there had been no trust, and let them know that they can get a copy of the trust from him if they would like to have it. But there are other ways of passing property, as you know, like joint tenancy, life insurance policies, pay on death accounts. And for those, there's really no central locating system to be able to find out if you're the beneficiary or entitled to that particular money or that particular account. Surprisingly, most people will find out within a few months if they're a beneficiary or not. There'll be some type of notice because of the need to do a probate proceeding or something else along those lines. But probably ought to basically, the first thing you do is at an appropriate time, ask the person who was closest to the decedent if there were going to be any estate proceedings, and if so, what he should expect.
Okay, thank you for that. So here's another hypothetical. My single mother died a year ago. I believe that my brother is her trustee, and I haven't heard or seen anything happen related to the administration of her trust. What can I do to get things moving?
Well, if you think there's a trust, then your brother should have, within 60 days, sent you a notice that you're entitled to see it. However, there's no policeman that goes out to the house and says you haven't sent your brother a copy of that notice within 60 days, and he may often ignore it. So as a practical matter, the first thing you do is you wait a decent period of time, 2 months, and then you call your brother and ask him, is there going to be some administration of mom's estate? If he responds rudely to you, then your next recourse is basically to retain a lawyer to send him a letter. Now, a lot of people think that a lawyer sending a letter is some special thing. It's really not. Lawyers are people like anybody else, and a letter really hasn't much legal significance. But sometimes the person who is the trustee is going to respond to something that the lawyer sends, because the lawyer implicitly can basically take the issue to court. And if that doesn't work, then the lawyer can file a petition saying under the probate code you've got a duty to show your brother the trust, and you better do it. Now, let's say there is no trust. Then what the lawyer would do would be simply to start a probate proceeding. Because you're a son, you're an heir, just like your brother, and you go to a lawyer and he starts a probate proceeding. There are judicial counsel forms to be filled out. You file it with the court and you send notice to your brother, and then there'll be a hearing at which you will ask the court to appoint you as the administrator. Now, once your brother gets notice of that, he's not going to just sit tight, because he doesn't want you to become the administrator. So he will eventually fess up and do what he was supposed to do. This is assuming, of course, that he hasn't already seen a lawyer who should have told him that he has a duty to let his brother know about the administration of the estate.
Okay, thank you for that. All right, now let's say we have a similar situation if my mother passed away, but in this particular case, she's remarried, and my stepfather is the executor or trustee. And now what do I do, or what may be the situation?
Well, this is the thing I kind of alluded to begin with. Often stepfathers and stepmothers become somewhat concerned when the children by their spouse's prior marriage start asking about the inheritance. Sometimes the surviving spouse takes the position that I was married and living with this person for the last 10 to 20 years, and therefore everything that I get from them in any way is mine to do with as I please. But what is very, very common these days is a form of living trust that is called a qualified terminable interest provision trust, or taking the first letters of each of those words, what we lawyers call a Q-tip trust.
Yes.
And the way it essentially works is it says when I die, my spouse becomes the trustee. My spouse's half of the property is his or hers to do with as they please. And when I say half the property, I mean community property, for example.
Yes.
But my half of the community property and my separate property will be held by my wife as the trustee, and my spouse is the trustee, I should say, and she can pay herself the income automatically, interest, dividends, rents. Often it says she may invade the principal for her reasonable support, care, and maintenance. But when she dies, I am supposed to, the rest of my half, or my share, goes to my children. Now, the surviving spouse, as the trustee, is under a duty to notify me that, just like any other situation, that your father has died, as you know, and you're entitled to see a copy of the trust. And thereafter, he or she is under an obligation to report to you every year at least, 6 months if you ask her to, showing you what property is there, what's been done with it, and what's left. The theory being that although you're not entitled to anything until he or she dies, if he or she is doing something improper with the money, you have the right